All right, Jeff, I would love an answer to the question, can I recover for my injuries if I am partially at fault?
That is a great question and a very timely question here in Florida. Um, you know, we often get cases where there's a rear end collision and our client is sitting at a stoplight and somebody hits them from the rear. That's easy. That's a no brainer. Almost always the fault is on the person who hits you from behind. But there are oftentimes cases where both parties have some fault. For example, if somebody pulls out from a stop sign into your lane of travel, but you are going excessively fast or way over the speed limit, they could argue that you bear some fault for the accident. In Florida, the way it's worked for the past 50 years or so is it's been a system of comparative negligence. And what that means is that, let me give you an example. If you have a case that's worth $100,000 and a jury finds that you are 10% at fault and the defendant is 90% at fault, well, then you can recover $90,000 because they'll knock off 10% due to your own fault. Um, or let's say that you happen to be 90% at fault on a $100,000 case, and the defendant is only 10% at fault. Well, then you can recover $10,000 against the defendant. And comparative negligence comes up a lot in slip and fall cases where you slip on some water at a Walmart or a Target, and they try to argue, hey, you should have watched where you were going, you weren't paying attention. So slip and falls are notorious for comparative negligence. The problem now in Florida is that earlier this year, our governor and the legislature enacted a new law. And that new law means it states that um, for any accidents happening after the effective date of the law, where the plaintiff is found to be more than 50% at fault for an accident, the plaintiff gets zero, nothing. So what's going to happen, I fear, is that insurance companies and insurance adjusters are going to make the argument in virtually every case that they can that, hey, you had fault. You're not entitled to anything. You were more than 50% at fault for this accident. You get zero. We're not going to pay you a dime. And so it becomes more important than ever to hire an experienced personal injury attorney as soon as an accident happens and you have injuries so that they can evaluate the liability issue. They can take photographs of the scene. They can go out to the scene. They can talk to any witnesses, take statements from any witnesses to help prove that you were not at fault. They can hire an expert to go out and reconstruct the accident and show exactly what happened, and do everything possible to prove that you are not at fault, or worst case, that you're not more than 50% at fault. And that way you can still preserve your recovery. So I highly recommend, especially with this new law here in Florida, that anytime you have a personal injury claim that you contact an experienced personal injury attorney as soon as possible.